Well, thank you. Thank you very much, William. I'm Tom Grant, and I am a scholar, teacher, and practitioner of public international law. That's the branch of law concerned with relations among states, international organizations, and any actors or entities who have dealings across the boundaries of states. I'm based at the University of Cambridge in the United Kingdom, where I am a fellow of Wolfson College of the University of Cambridge, and my primary academic home is the Lauterpacht Center for International Law, which is also part of the University of Cambridge. I'm originally from the United States. I've been in Cambridge for a good part of the last 20 years, first as a PhD student in the 1990s, and then later in my present capacity. As for the book, the book is first of all an overview of the arguments that the Russian Federation put forward in 2014 and after to address its invasion and annexation of Ukraine. I think it's one of the early, or one of the first. The book is one of the first accounts of that line of arguments from the Russian side. And I think as a lawyer, it's one's job to take the other side's positions seriously as legal positions, even if they're wrong. And the book does come out pretty strongly explaining why the positions of the Russian Federation, especially in respect of the annexation of Crimea, are simply not tenable legal positions under modern international law. They don't hold water for a number of reasons we can maybe go into. So that's one purpose of the book. The other purpose is to, I think, sound a more general alarm about the danger of major countries, or really any countries, disregarding the territorial settlement between countries. Countries, at least since World War II, have done a fairly good job of clarifying where their territory starts and ends. It was not always the case that countries had good relations on that sort of a question. You had a long history of conflicts over boundaries, over territory. And we, if you want to talk about a community of states, there was a community that came together in 1945, and after the disastrous results of the two world wars, it was decided that it was not acceptable to have that sort of conflict again. So if anything was accomplished in the last 71 years in international law, it was the solidification of the principle that once you have a boundary, the boundary stays where it is unless you agree or negotiate or adjudicate the boundary. You can always go to court if you agree. You can go to arbitrators if you agree. You can go to a negotiation table if you agree. And in that way, you might change a boundary. States do this. They do negotiate boundaries. They negotiate maritime boundaries, particularly. But what you have not seen very often at all since 1945 is the use of force or the threat of force to compel a country to change a boundary. If you go back to an old version of international law, a pre-modern version going back even before World War I, but into the 19th century, it was actually accepted that you could acquire title to territory by conquest. Conquest in the old treatises on international law is often listed as one of the mechanisms by which countries came to possess territory. That might have been fine in the 19th century, but we saw that this carries enormous costs because the frictions and the misunderstandings and ultimately the conflict that can erupt if that modality of territorial acquisition is accepted are simply too much to bear. The world wars were too much to repeat. We recognized wisely that that's something you couldn't do again. And one of the most important innovations for international law was to absolutely prohibit changes of boundaries by force. Now, that's something that one of the things I say in the book, which is quite striking when you consider present-day Russian policy, is that the Soviet Union, whatever its faults, was very, very much committed to the idea that boundaries are settled where they are. The Helsinki Accords contain boundary provisions that make clear that Europe's boundaries will not be changed except by agreement. And Russia, well, the Soviet Union at the time in the 1970s, was adamant that those provisions be incorporated into Helsinki. Our side, the Western side, was more concerned about domestic affairs and human rights. But the Soviet side said the most important thing is that the boundaries, once settled, stay settled unless all parties agree, relevant parties agree to change them. So it's, from a historical perspective, an amazing volte-face, sort of a 180-degree turn by the Russian Federation to turn its back on that principle, which its predecessor, the USSR, the Soviet government, had been actually quite you might even say a good citizen on that point. There are many respects in which it was not a good citizen. We don't need to, we know that the Cold War had its terrible conflicts. But one thing that we did not see was forcible acquisition of territory by countries. So that's really the motivation behind the book, was to, first of all, address what Russia had done in a lawyerly way, and then to think about the larger implications. And I try not to pull any punches about that. I think the larger implications are very serious. If you look across the states that border Russia, which had formerly been union republics of the USSR, you have several situations where a mixture of internal separatist political movement and external support, mainly from Russia, has led to what some people have called frozen conflicts. I'm somewhat doubtful about the utility of that expression from the standpoint of law, but it has entered the vocabulary of politics. And you look at Transnistria in Moldova, the Nagorno-Karabakh conflict between Armenia and Azerbaijan, and then the Abkhazian and South Ossetian situations in Georgia. They have gone on a very long time. These are conflicts that erupted in the immediate aftermath of the USSR in the early 1990s. And in fact, with Nagorno-Karabakh, the writing was on the wall even in 1989, 1990. One concern people are expressing today is that the situations in Crimea and in eastern Ukraine, in Donbass, might turn into something like a so-called frozen conflict. That is to say, the situations might simply become static, and the parties involved, however bad these situations are, will simply learn to live with them. That's a theory which you see expressed even in some governments in the last year or two. In my view, there are some salient differences between the so-called frozen conflicts of the 90s, which have dragged on to the present, and what we've seen in Ukraine. With respect to Crimea, the principal difference is that the Russian Federation is actually very clear about what it intends to do and what it has done in Crimea. By contrast, one of the hallmarks of these so-called frozen conflicts is a high degree of ambiguity about where the different parties stand. You have claims by separatist groups to be independent, but nobody recognizes the claims. In fact, Russia did not even recognize the claims until 2008 in Abkhazia and South Ossetia. It still does not recognize Transnistria formally as a country. So there was sort of an intentional ambiguity in how Russia approached those so-called frozen conflicts. Crimea is not ambiguous at all. Russia's position is all too clear. The position is that Crimea constitutes one of the federal entities of the Russian Federation, or two of them actually, Sevastopol being supposedly a separate unit. But that's quite different from trying to string out the conflict indefinitely. What Russia gives every indication of wanting to do is to settle the matter once and for all on Russia's terms. That's very different from a frozen conflict. It's also a lot more dangerous for the international law system for the reasons that I was just saying. You had a general agreement going back 71 years now that boundaries that have been settled are not to be changed by force. You can use force in self-defense, and there's a lot of debate about how you define self-defense, especially when you start talking about preemption or preventative action. That's an important debate. It's a very consequential debate. But we agree that you can use force if it's in self-defense. What you cannot do is change a boundary by force. So in Crimea is, I think, very different. I think as a category, it's a different thing. It's from the frozen conflicts. Now, with the eastern regions, if you go to the so-called Donetsk and Luhansk entities, or whatever they call themselves now, these start to look a little bit more like the so-called frozen conflicts. What you have are separatist groups, supposedly, and they are receiving material aid from Russia. That aid, there's a lot of argument from Russia about just what that aid is. Russia has denied that it's giving aid, but it's pretty clear. If you look at the information on the ground, it's pretty clear that it's very serious material aid coming from Russia, both men and materiel, and a certain ambiguity as to where it's going to lead. Russia has not recognized those entities as independent countries, but it does support them, even though it sometimes denies it supports them. So the question is, what is the long-term outcome going to look like in eastern Ukraine? And there is a real danger that it could become a sort of static situation where Russia gives just enough support to keep those two separatist groups alive, not enough to really make them self-sustaining independent entities, but in that way create a constant ongoing crisis for Ukraine. And that seems to me to be the strategy behind the so-called frozen conflicts of the 90s. They led to the countries involved being in a sort of limbo. You don't know where you stand if you have a separatist group occupying part of your country, but you're not able ever to really just cut to the chase and achieve some sort of final settlement. It's a sort of never-ending crisis. That's a danger. Now, I think where we stand now, the situation in eastern Ukraine is still highly fluid. You have not had a sort of crystallization of the lines such that you had in Transnistria, for example. So I think there's hope that we can prevent, when I say we, I mean the international community, Ukraine and its friends, but even Russia, if we can appeal to Russia's frankly, I think it's a common sense approach by Russia wouldn't be doing this, but it's not for me to tell Russia what makes sense for Russia. But one of the things the book addresses is the risk that I actually think this exposes Russia to. It's not an immediate risk. It's not likely. I mean, nobody's going to have a war directly with Russia over these. I mean, sadly enough, it's sort of a Ukrainian. It's a problem that Ukraine has to bear the burden of, because NATO does not extend its guarantees to non-members the way it extends its guarantees to member states. So, as a non-member state, Ukraine is, it's a third party as far as NATO is concerned. Obviously, NATO is worried and watches the situation, rightly so. But you're not going to have it's very, very unlikely, and it would not be desirable, obviously, to have a U.S.-Russian Federation direct conflict. So to that extent, the burden lands on Ukraine to deal with the situation. But one of the things the book addresses is where this leads to, where this would lead for Russia if the principle behind it, as stated by Russia, starts to take root in the understanding of international law writ large, not just for Russia, but for other countries. And if we look at Russia's argument, what it says is that Crimea has a lot of Russian speakers. Well, we know, yes, that's true. There are a lot of Russian speakers in Crimea. And it said that Crimea used to be part of the Soviet Union, the larger, which Russia is the successor state to the Soviet Union for international law purposes, or for most purposes, Russia is the same state as the Soviet Union, even though it underwent a gigantic convulsion and all sorts of change, and of course the loss of the Union republics that separated. But in terms of succeeding to treaty rights and obligations and so forth, Russia, for example, kept the Security Council seat. Russia kept the treaty obligations and rights of the USSR for most purposes. When you have a country as important as a permanent Security Council member, like Russia, asserting a new rule of international law, this is one of the ways that new rules start to actually take shape in international law. It's not enough for one country to say this is now a rule, but it is the first step. It's one of the first steps toward creating a new rule. And if the rule says that entities' territory that used to be part of our country, we can seize by force in order to recover, as it were. There's a serious danger in that. And the danger is that if you look back through the history books over 100 or 200 or 300 or 1,000 years, there are lots and lots of territories and lots of boundaries that have undergone change. And the changes in the modern era have been by agreement or by adjudication or arbitration. But you don't get a right to take it back just because at some page in the history book it used to be yours. The problem with that is the history books have lots of pages, and your history book might be different from my history book, and then what page do you choose? You've opened the door to endless argument about who gets what territory when you start to introduce historical arguments. And I mean, the president of the Russian Federation was explicit about his historical thinking. He was actually, I mean, he did us a service in a way by being very, very expansive in his description of what he was doing. He said this used to be part of the Soviet Union. It was wrongly taken from the Russian Union Republic and attached to the Ukrainian Union Republic, so he said. That was his argument. The thing is, it was a settled matter in 1990. It's not a question of what the Soviet domestic law system did in the 1950s under Mr. Khrushchev. The question is, what did Russia in 1990, 1991 accept as regards the other Union republics? And the republics in the Alma-Ata Declaration, in the Minsk Declaration, this is at the time of the independence of Ukraine and of the other republics, all of the participants, all of the states, Russia and the others, were explicitly clear that the boundaries inherited from the Soviet Union as at 1990, 1991 were to be the final settled boundaries. And that was a good thing. It was very wise on the part of the leaders at the time to come to that agreement. They had a lot of domestic problems to deal with. It was, as I said, a period of enormous convulsion. So they decided, let's not have wars. Let's not have conflict over boundaries within the former Soviet system. Let's just accept that these boundaries are final. They're settled. And in that way, they made all of the old Union Republic boundaries international boundaries. It's a very sensible way to do things when you have plenty of other problems to worry about. And it's what the Latin American republics did after they gained independence from Spain. They came to a general agreement across Latin America that there would be no end to warfare and conflict if you open the door to claims to change the old Spanish imperial boundaries. It was very sensible. We saw what happens if you don't accept that. We saw that in Yugoslavia in the early 90s. Cooler heads said, look, that's the rule you must apply. The boundaries that you inherited from the old state are the ones you ought to keep. Sadly, there were a couple of parties involved that didn't think that that was the best way forward, so you had a terrible war. Especially, everybody remembers Bosnia, but of course there was Serbia and Croatia. They had a terrible conflict in the Vojvodina and Eastern Slavonia. So that's the sort of conflict that the parties in the former USSR at the very end of the USSR very wisely avoided. I mean, if you remember back then, going back 27 years now, people were very afraid that Yugoslavia was going to be what happened across the former Soviet Union as well. And thankfully, by and large, you did not see that sort of eruption of violence. Why? Very largely because, from a lawyer's standpoint at least, the explanation is the countries wisely agreed that the boundaries were to be settled. So, in a way, what the Russian Federation did in March 2014 was they threw out the window one of the key building blocks of the relative stability that they achieved after the breakup of the USSR. I mean, it's not, you wouldn't, you're thinking about history in the long, long run, looking at 1,000 years, you wouldn't necessarily guess that the breakup of the USSR would have been peaceful and basically, not a non-violent. And obviously, you had the conflicts in Chechnya and Nagorno-Karabakh. They were serious conflicts, but overall, the big players dealt with one another as civilized equals. So the real danger is to throw away that principle, is to throw away what earned us, or earned our friends in the former Soviet Union, a relatively smooth transition, notwithstanding all of its problems, but it was not World War III, or for that matter, major interstate war like between the Serbian and Croatian forces in Yugoslavia. You didn't have a giant Yugoslavia. a very good thing. It was a great accomplishment. So that's why the moves that Russia has made against Ukraine, both in Crimea and in the eastern regions, is really shocking. It's to throw away the agreement that really did a lot of good for Russia. And again, if I could just go into the historical aspect a little more broadly, Mr. Putin's historical thinking seems to say that if it was mine at some point in the past, I can take it back, never mind what agreements were made, and that certain agreements in particular just weren't valid. I'm going to pick and choose which agreements I think are valid agreements. Now, in the conclusion of the book, I point something out which I'm glad to have heard a few people in Europe and the U.S. talk about, but it's not talked about very much. But China, of course, was not the borders of China today are recognized. None of us would doubt that those boundaries are the boundaries of China, except that in China itself, there's a very strong legal doctrine that China has espoused even before the People's Republic, going back to the Republic after 1911. China was very clear that there were a lot of treaties in the 19th century that were not fair. They called them the unequal treaties. These were the treaties that the Chinese Empire, entered into with European countries at a time when the Chinese Empire was very weak. All of the military and political and economic advantage at the time was in the hands of France, Britain, and the other European powers. China more or less accepted the treaties that were presented to it by the Europeans. But the doctrine of the modern Chinese state, going back even to the Republic, has been that those treaties are not binding. It's by those treaties that Russia acquired Siberia. And that's just a fact. You can read the treaties. It's the eastern part, the eastern third of Siberia. Now, if you put yourself in the shoes of the head of state of a country, a vast part of which was acquired by your country under a treaty which this very large neighbor, as a matter of its own historical doctrine, says are not valid treaties, do you really want to say that old treaties that you don't like can be ignored and boundaries can then be recovered, territory can be recovered by force? Now, I'm not saying China is going to use force against Russia. Of course not. I mean, that's not going to happen tomorrow. But looking in the long term with demographic change, movement of people, and settlement of Chinese people in Siberia, the relative decline of Russian population across the country, it just doesn't strike me as really prudent for Russia to give any credence to that type of argument. But that's the argument Russia makes with respect to Crimea. They say that it was ours, it was unfairly taken, we can take it back. Well, I wouldn't say that if I was in the same neighborhood as Russia. The thing about referendum is that in a normal circumstance, a referendum is strictly a matter of domestic law, and you evaluate it in the first instance by looking at how the domestic legal system considers the referendum. So, for example, when the Scots wanted to have a vote on independence, they talked about it in Edinburgh and they talked about it in Westminster, in the UK Parliament, and they agreed within the UK system to have a referendum. And so the rest of the world really had no reason to question that referendum. It was agreed by the relevant parties. The thing about the referendum in Ukraine, in Crimea, the Crimean area of Ukraine, is that, first of all, it wasn't the result of any negotiated settlement with the government of Ukraine. The parliament in Kiev, the executive officers in Kiev had nothing to do with it. It was completely confined to people in Crimea. There was no parliamentary settlement. It wasn't a Ukrainian law that said, let us have a referendum. So that's a big difference. But another difference is the heavy involvement of an external military force. There was sort of funny kind of hair splitting about whether the force was external. Many of the Russian forces were already there. Well, the United States has forces 20 miles from Cambridge at the air bases. Those are external forces. And if they ignored the status of forces agreement and invaded Cambridge, which I don't expect them to do, they wouldn't do, but if they did, that would be an invasion. It doesn't matter how they got there. If they're using force against the will of the host country, that's not just a tourist visit. So the Russian forces in Ukraine, practically, for all intents and purposes, were invading forces for the reason that they were not acting under the treaties that had invited them to be there. And it seems that other forces were introduced as well, but that's legally a fine distinction. The point is, when you have basing rights, the basing rights do not allow you to overthrow the local government and seize territory. So the referendum was held in a sort of under an emergency situation in which foreign armed forces had practically taken over the region in which the referendum was held. So that's a problem. First problem, the referendum is not the result of Ukrainian law. It's just a local exercise. Second, it's a local exercise with an external force overseeing the conduct of the referendum. The third point is that, or a third point is that the referendum took place in an extremely compressed timeline. American presidential elections seem to never stop, but even in the UK, for example, where the government has relatively short election periods, it's still a real election period. You have weeks and weeks to actually talk about what's going on, and the candidates can present their arguments. Well, this all happened in the space of about a week. There was a rapid escalation. A declaration was made that there would be a referendum, and before you know it, there was a referendum. That's very problematic. Now, you're not going to find any explicit international text. You're not going to find a treaty that says how many days do you need for a referendum campaign? How do you write a referendum question? You're not going to find explicit language in a treaty telling you how to do it, but you will look at how countries have responded to referenda in other places at other times. And the most successful referenda in modern international law have had some degree of either international supervision or a high degree of domestic buy-in by the relevant legal and political institutions. You have the Scottish referendum where the entire UK system said, yes, you may do this, let's do this. And then you have referenda in some of the old colonial territories, like what's now the Indonesian part of New Guinea, or parts of Cameroon, where the United Nations itself passed resolutions and was involved in the referendum process. So there was no doubt that those referenda were carried out in a fair way and ascertained the actual desires of the people in the territories. So to carry out a referendum without consultation with the country concerned, to do it under armed occupation, and then to carry it out on such a rapid basis is really untenable. Just does not create any confidence in the result. So that's those are several considerations that really undermine any sense of validity that the Crimean referendum might otherwise have had. It seems to me that much of the strategy taken so far from a lawyer's standpoint makes pretty good sense. The strategy has involved looking at different dispute settlement organs, different courts and tribunals that are available. You're not going to, it's very unlikely that you're going to achieve a sort of thunderbolt victory at a court and then all of a sudden Russia is going to withdraw from Crimea. Not likely to happen. But it's absolutely critical that you maintain a strong position that makes it totally clear that you do not accept the status quo. You're not going to accept the status quo, and it helps also to keep your allies and your friends on notice that you're not giving in on this. And especially, the countries that are probably Ukraine's best friends, the United States, the Western European countries, are pretty legalistic. It's much the stronger your legal positions, the easier it is to make your arguments to parliaments and to Congress and so on. I think the institution of proceedings at the International Court of Justice makes good sense. I haven't seen the papers, the submitted papers, which I don't think are yet public, but it sounds like the government has done a smart job of looking at Georgia's case against Russia from 2008. Georgia, in retrospect, was a little bit precipitous. They should have set the stage a little more carefully. There are in many of the treaties that create jurisdiction in international courts and tribunals, you have requirements to negotiate before you institute proceedings. Now, I think there's a certain delicacy here because I don't think Ukraine should negotiate the status of Crimea, and Ukraine has been smart not to negotiate the status of Crimea, but it has set the stage, I think, pretty skillfully for the case at the International Court of Justice by sending out diplomatic communications to Russia saying, look, this is not acceptable. Let us sit down and sort this out, meaning let's find a modality, a procedure for you to get out of Crimea. That makes good sense, because then you can say, look, we've attempted to deal with this outside of court. Hasn't worked. No progress. It's been a couple of years now. At this point, it is time to go to court. So I think that looks. I have a certain sort of a cautious optimism about that. Repeating, but to repeat, obviously these cases when you're dealing with the sort of, it really is aggression, armed aggression. It's not likely you're going to get a magic. It's not a magic bullet, but I think it's the right thing to do. I think it's right also to have looked at the investment case, the investment treaty. There's a Ukraine-Russia investment treaty. Investment law was not designed to deal with armed aggression. That's not why you have investment treaties. Investment treaties are so you can get down to business and have economic growth and development. But there is some possibility that Ukraine could get some traction through those treaties, and it's been reported that there are a handful of cases now under the Ukraine-Russia bilateral treaty. I think that makes sense. I think you want to keep as much pressure on Russia through legal channels as you can. I mean, compared to fighting a war, it's pretty cheap. It's not a huge expenditure. It's not negligible, but compared to the cost of the conflict in Donbass, it's not that much of a burden. But it helps communicate to the world that you're not giving in on any of the positions. And if you can get something, if you can get an organ of the UN. Like the International Court of Justice, to add its voice to your case, to your side, that's helpful. You already have the General Assembly, which has passed two, I think, quite useful resolutions, making clear Crimea is part of Ukraine. It's now clear that all UN organs, including the human rights organs, if they deal with Crimea, have to go through Kiev. They are not to go through Moscow. Obviously, in this whole world, there's a degree of symbolism around this stuff. As I said, it may not have immediate impact on the ground. The problem is, if it's a long game, you better play the game day by day and not give in at any step of the way, because any concession you make, the Russians will grab hold of and use against you. So I think it's right. I think it's right for the government to have taken these steps and brought these cases. As I said, these cases are mostly in very early phases, so we don't know the details. We don't know what the pleadings look like. If the ICJ case goes ahead, the International Court of Justice case, we will see the actual legal arguments when it has its public hearing, which could be could be well over a year from now. But I think so far I'm cautiously optimistic that it looks like a smart strategy is being followed. Yes, absolutely. I mean, it's interesting. I hope it doesn't take 40 years, but in the year 1940, the Soviet Union annexed Estonia, Latvia, and Lithuania. And the United States made clear we would never recognize the forcible annexation of the Baltic States. Now, by the 1950s, 60s, 70s, it was de facto the case that the Soviet Union ruled the Baltic. Nobody doubted the Baltic was under Soviet control. But at the symbolic and the legal level, the United States continued to be clear that the Baltic states were not part of the Soviet Union. Now, again, it took 40 years, but there was strength in that position, almost 50 years. But there was great strength in maintaining consistency over that entire period. I rather think it'll take a lot less than that. It's not going to be a half a century, but it may, but it's not going to be next month or next year. But there are cases, and sometimes the international law system works very slowly, and it can be very depressing if you're carrying the cost of something like the invasion, of armed aggression. But it's some in a funny way, it can be a more powerful system than it looks like at first. The Budapest Memorandum is a curious instrument. It's something I've addressed a little bit in some writing. Let's see. I think in the Polish Yearbook of International Law, I have a piece about the legal character of the agreement. There's a debate about whether the Budapest Memorandum is a legal commitment or just a political commitment. To some extent, I think the debate is beside the point. It's beside the point because failure to give really strong backing to the beneficiaries of the agreement, in particular Ukraine, sends a very bad message about nuclear proliferation. The bargain was, as you know, the bargain was that the parties, and it wasn't just one Budapest agreement, there was a Kazakh one, a Belarusian one, and most famously a Ukraine one. But under the agreement, the three countries agreed to give up their weapons, their nuclear weapons. And in return, they got a security guarantee. Now, it's a good deal if you have confidence in the security guarantee. It's not a very good deal if the security guarantee is abandoned. And this has long-term impact outside Ukraine because we're in a world where we would like to stop nuclear proliferation through whatever tools are available. And using force is always the last resort. We would rather not have to go to the military option to deal with proliferators. We'd rather be able to bargain and reach good bargains. But how good is a bargain when you see what's happened under the Budapest Memorandum? You had a country with a large nuclear arsenal. It gave the arsenal up, and it gave it up on the promise that it would then have permanent guarantee of its territorial integrity. And that guarantee looks, well, not so convincing today. It sends a bad message to would-be proliferators. Why deep proliferate when that's going to get you nothing at all except a paper-thin guarantee? So whether it's a political agreement or a legal agreement, the result over the last several years, since 2014, sends a potentially very bad message to any country thinking about obtaining nuclear weapons. Why not do it? So it worries me. Just quickly, enforcement mechanisms in a treaty like that, which certainly has political aspects, whether or not it has legal elements as well, are very hard to negotiate. It's difficult to get countries, when dealing with issues like that, big strategic issues, to agree, for example, to international court jurisdiction or arbitration jurisdiction. It's not theoretically impossible, but politically it's very difficult, and you don't see that sort of big strategic agreement often containing binding third-party dispute resolution. The most you might see is a consultation clause, and that's what you've got with Budapest. And consultation is a very low bar. It doesn't give you very much. It's easy to satisfy that. In fact, one of the things the Foreign Office of the FCO in the UK said was, we consulted. After the crisis began in 2014, we consulted, and there's a good case to be made. Yes, they did, and that's all they had to do. So it's problematic. It's not very satisfying, but I'm afraid that's pretty much the position under the Budapest Memorandum. Absolutely. Well, that's a difficulty. The thing about the relations between Ukraine and Russia today, the Russian Federation not only agreed to the boundaries at the outset in 1990, 1991, but there were subsequent agreements through the 1990s and early 2000s to actually deal with the housekeeping surrounding those boundaries. When you have a boundary, you sometimes do not know exactly where the boundary posts are and so forth, but there were subsequent agreements in order to deal with that sort of housekeeping, so-called demarcation of boundaries, boundary crossing agreements, and so on. If you look at the agreements on the basing of Russian troops and naval forces in Crimea, those agreements reiterated Russia's respect for Ukraine's boundaries. So again and again, not just in 1990-91, but right through the 2000s, Russia made clear that it accepted and respected the boundaries. So as you just pointed out, what does that say about treaty commitments in the future? If Russia were to promise some form of settlement, well, the problem is we've seen that already, and the settlement wasn't respected. So it's a problem. I think one thing that's interesting is that Russia's president, I think, knows what he's doing, at least in the sense that he spoke a lot about modern international law, and he gave a full detailed speech. He seemed to really mean it. It sounded sincere. I was a bit surprised at how deeply he got into those details. And if you were just a pure academic, you would say, well, that's kind of reassuring. He takes an interest in international law. The problem is the way he takes an interest in it, I think, is very deleterious to the interests of Ukraine, and actually, long term, I don't think it's in the interests of his country. I think Russia will come to regret having adopted this view, this new understanding of international law. The other thing that I hadn't really given thought to, but started to think about in writing the book, is that you have a shift in Russia in the last decade or so in respect of human rights, transparency, democracy. And on the one hand, it's each country's own business how it runs its domestic affairs. But the sort of movement against human rights and transparency, press freedom and so forth in Russia seems to be very closely tied to this new international policy. It seems that the Russian Federation has the view that if democratic values start to take root in Russia's neighbors, like Ukraine, then somehow Russia has in Russia's view, a legitimate concern to try to push that back. Now that's pretty radical. It's perfectly acceptable to say that in your own country, you call the shots. And if Mr. Putin and his supporters really want to reject human rights treaties and so on, at the end of the day, under traditional international law, that's a matter for Russia. But it's not a matter for Russia to tell other countries what to do about human rights, transparency, democracy, press freedom, and so forth. So if your neighbor is moving more toward a modern progressive view of human rights and related principles, that does not give another country the right to intervene. So it's, in that sense, this is sort of like an old Soviet doctrine, the doctrine that said if the Hungarians or the East Germans or the Czechs were to rise up to try to become more democratic, Russia, the Soviet Union, had a right to intervene and restore the Soviet order. It's a little bit like that. It seems to be that Mr. Putin wants to throw away the stability of boundaries, which was a solid Soviet principle, but then also go back to an equally deeply entrenched Soviet principle that said that the Soviet Union could intervene to restore its form of government in various countries. That's to me a very worrying phenomenon. This sort of marriage between Russia's domestic agenda and the international agenda. It's again, as I say, it would be wonderful if Russia became a solid democracy with press freedom, etc. But at the end of the day, it is Russia, in my view, and in the traditional international law view, it's every state controls its own domestic affairs. The problem is, it seems now to be bleeding over into Russia's international policy, and that's definitely not something international law accepts. So it's something that I found alarming in my reading of contemporary Russian politics and international law policy. It's something we have to keep a very close eye on, because that's the biggest danger. It's if that starts to happen farther afield, then really Ukraine's fight is not just Ukraine's. It starts to become a general conflict. It becomes a concern for everyone. I think there is some correlation between China's much more aggressive approach, if I may, in the South China Sea. I think that the escalation there in the last couple of years, certainly it's been at the same period over the same period of time. So there's a sort of the timeline is similar. Whether it's cause and effect, it's very hard to say. But I think it's something that should concern people. It's a really good question. I think being a journalist to do a good job as a journalist is very, very hard, and there are many journalists who try very hard. An issue like this is problematic for journalists because journalists are taught to try to be balanced. But the problem is there are situations where one side is simply wrong, and you're not doing anybody a favor to present the case as if the two sides have equal merit. Invading, annexing a country or part of a country, you don't do that under the modern law. Iraq tried it with Kuwait. Thankfully, we didn't let them get away with it, but that was a situation where we had the ability, Russia itself. And think of that. One of the reasons Russia supported us in 1990 in Iraq is that the old Soviet Union was such a firm believer that in the stability of international boundaries. I would say that journalists are trying their best when they try to give a balanced view, but sometimes they need to step back a bit and look at the big picture. And I'm not sure they've done that Some of them have. There is good reporting on Crimea, but there's also reporting which is very unfair to Ukraine. Thank you. Oh, thank you to you and your viewers for your patience and for listening. I'm very happy for the opportunity to talk to you.